Good morning. 2 days ago, Ethan Crumbley made his second court appearance after months ago, official judge denied him going to juvie. But there is new evidence going along, so let's jump right into this. Let's take a look at what happened.
Rape, torture, and ultimately killed a female classmate. He expressed delight in torturing a family of baby birds, and he wrote about the joy he received in listening to them squeal as he killed them. He spoke of his admiration for Adolf Hitler and Jeffrey Dahmer, specifically stating, "When you die, you need to be remembered for a long time, doing something that will make people think of you until time ends." The evidence will show that the defendant had a very specific and detailed agenda leading up to November 30th. In his journal, he described the type of gun he needed, who his first victim would be, and ultimately he expressed that he would surrender so that he could witness the pain and suffering that he caused. This shows a sophistication beyond that of an average 15-year-old. The defendant's journal has been admitted for an in-camera review, as we believe the entire content must be considered when determining what is in the interest of justice. The court must also consider the nature and circumstance of the alleged offense. This court is well aware of the horrific event that happened on November 30th. However, now the court has an opportunity to review and see just how calculated and methodic this defendant was. The people, again, have admitted for an in-camera review a video that was retrieved from the defendant's phone the night before the shooting. In the video, the defendant identifies himself as the next school shooter. And in an unfathomable way, he attempts to justify his future actions. To place this defendant with other at-risk juveniles who are presumably the same age as his victims would be contrary to the rehabilitation of those at Children's Village and pose a potential risk of harm to their safety. Another factor that the court must consider is the prior delinquent acts of this juvenile. As stated in the people's brief, despite having no documented juvenile history, the defendant's antisocial behavior is very concerning. The evidence will show that he bragged about wearing a mask to the public. He enjoyed his dark side. The defendant isn't who he appears to be. He allows people to see who he wants them to see, and only those close to him, such as his parents, would understand or recognize it. He is fascinated with violence, weapons, and seeing others suffer. He cunningly placed a bird in the boys' bathroom at Oxford High School, and in his journal, he later reveled about how happy he was for not getting caught. His behavior, however, continued to escalate. And when the defendant committed those premeditated murders on November 30th, he did so with the intent to be remembered, to terrorize the community, and to gain recognition. Pursuant to the statute, the court is also allowed to consider other relevant factors. The evidence will show that despite the defendant being held in the Oakland County Jail, he is not completely isolated. He has the ability to watch television. He has access to a tablet wherein he can communicate with family and friends. He can play games and he can read books, all of which he's taken advantage of. He has phone privileges. He receives mail and he has a commissary account. Since his placement in the Oakland County Jail, he has been monitored every 15 minutes, and any issues or concerns that have been brought regarding his care have been taken care of expeditiously and will continue to be addressed at that same level of efficiency. In conclusion, it is important to note that the statute in question specifically emphasizes that the court is to consider what is in the interest of justice, not what is in the best interest of the juvenile. Thus, it is the people's position that it is the defendant's current placement in the Oakland County Jail that is best suited to meet his specific needs, to maintain and protect the safety of the general public, as well as to protect the juveniles at Children's Village. Hence, we believe it is in the interest of justice that he be confined in the Oakland County Jail. Thank you, Your Honor.
Thank you, Ms. Washington. Ms. Dalton?
Yes, sir.
Your Honor, defense completely understands the serious nature of the charges that Mr. Crumbley has been charged with. But the statutes that were quoted and the JJDPA that sets out the guidelines for this hearing tell the court to look at other things, not just specifically the charges and the events of that day. Ms. Hott, myself, and Ms. McKelvey have had the pleasure of meeting Mr. Crumbley at least 12 times. The prosecutor is arguing from a place of what they see in black and white, what they see on his phone. All of these events obviously transpired prior to my client being charged. I think it's going to be very important for the court to look at what's happened since he has been charged.
Since when he's been charged. So far what happened is they're requesting, the defense is requesting he get transferred from Oakland County Jail to a juvenile detention center. I don't know what's going to happen or not, so we're going to continue watching to find out. When we come back, more from the defendants, more from the defense attorney. We'll see if he gets sent. He continues to be sent to stay in a jail or get moved to juvie. In other words, we're going to hear what they have to say, and then later we'll see what the parents have to say. Please don't go away. Since this week, Ethan Crumbley is now on trial, and they're requesting that he get transferred from Oakland County Jail to Juvenile Detention Center. But could it really happen? Remember on the first day, they denied him going to juvie because this and that and the other. Let's see what else they have to say.
And that's the questions that we will be asking of the witnesses today. Because the factors that are laid out for the court to consider, as I stated, only one part of those factors are the allegations and the events surrounding the charges. There are a number of other things that the court must look at. I believe that the evidence will show that in the time leading up to these events that my client was hallucinating, that he was seeing things, he was hearing voices, he was not sleeping, he was extremely anxious, he was not eating properly, and that he had asked his parents to see a therapist. And at the time of this event, my client was not in any sort of therapy. As to the isolation, Your Honor, we will be arguing that the appropriate placement for Mr. Crumbley is at the Children's Village. He is being housed currently in the clinic facility in the Oakland County Jail. It is essentially a cement cell with a glass door, and because the rule is that he has to be out of sight and sound from adults, he has very little interaction with anyone. So yes, there is a deputy that peers in at him every 15 minutes and signs off that he is doing what he needs to be doing and that he's safe. But our testimony will be that this extreme isolation is actually not beneficial whatsoever and actually harms Mr. Crumbley. Yes, he has access to a tablet a couple of hours a day. It's not something that is housed in his cell with him all the time. He does have access to a phone, but unfortunately Mr. Crumbley does not have the numbers of any family members, so he's not utilized the phone whatsoever. The tablet is set up for communication, so strangers email Mr. Crumbley, and he has the ability to respond to those emails. I do not think that is enough to argue that he is not being isolated. He interacts with a caseworker, he interacts with a psychiatrist 1 time per week for minutes. Other than that, if he's not meeting with myself, Ms. Hopp, or Ms. McKelvey, he's not interacting with anyone except when they're handing him his tray of food. We will be arguing that the jail is not equipped with handling juveniles in respect to any type of activity. He does not leave his cell whatsoever. He has, and I know that there are protocols because of COVID and most inmates are not receiving any type of rec or gym time, but he is essentially not leaving his cell at all, except for a shower, or if he's being moved to a visitation booth to visit myself or one of the other counsels. So at the close of this hearing, Your Honor, we will be asking that he be moved to Children's Village. I do think that is an appropriate place for him. There are other juveniles charged with murder that are housed in that facility. This would not be the first time. And we feel that due to his age being 15, and although he is educated and a very bright young man, I still think the appropriate placement for him is at Children's Village.
So what they're arguing about is whether he would stay at the jail and get moved to juvie. Listen, he's 15. You don't send a 15-year-old to adult jail. If he's a juvenile, he goes to juvie. He goes to juvenile hall. If you're under 18, you are a juvenile. And just today, James and Jennifer Crumbley are back in court for day 2 of the preliminary hearing. But before we get into that, let's read the article first. I'm not going to be playing you this thing. It's live right now. I am not going to be playing you this thing, but I'm going to read it because this was live just an hour ago. This was just about an hour ago. There's more evidence being presented today in the case of James and Jennifer Crumbley. The parents alleged of their son Ethan. Today's the second court date for the Crumbley's preliminary exam, and they're expected to get more of an idea of what evidence the prosecution will use in this case. 5 witnesses testified during the preliminary hearing. One was the caretaker of the Crumbley's horse takers who texted with Jennifer on the day of the shooting, and there were 3 employees from Jennifer's workplace also testified, including her boss, who she confided that he's going to kill himself. He must be the shooter. I need a lawyer. Ethan did it. The last person was Detective Edward Wignowski. Can't pronounce his name. From the Oakland County Sheriff's Office. The last witness takes a stand was February 8th and resumed the cross-examination today. But the defense attorney, Shannon Smith, began with questions about various text conversations between James and Jennifer Crumbley as well as their son, Smith. Smith first addressed a question about the Crumbley's knowledge of their son's social media usage, which is part of the evidence that Rogowski had collected during the investigation. But here's the catch. Neither Jennifer nor James were aware of Ethan's other Instagram accounts or disturbing comments left on the post. The other accounts also have various posts of photos and ghosts of mysterious figures. Smith argued there was never an example of text between James and Jennifer where the parent expressed concern their son may be in danger to others. In the grand scheme of all text between James and Jennifer, although they talk about their own things, we can agree they discuss their son frequently. So same discussions were part of the prosecutor's question for Wignowski. During various text messages, Ethan tells us when he's worried about a mental state and he talks about the dark side. So yeah, I'm not playing you guys the thing, but I'm going to play you a portion. I'm going to play you a portion of this when we come back to see what your evidence, but I'm going to show you the witnesses. We'll be right back. Today we're bringing you the very latest from Oxford, Michigan, where accused 15-year-old shooter Ethan Crumbley is now in jail, but he might be moved to juvenile detention center if the judge agrees. If the judge says he needs to stay in jail, then he can't go to juvie. If the judge agrees with Ethan's attorney, then we could see him go to juvie. But what about the parents? Well, they're back. They're back today with new testimony, new evidence from 5 people. Let's take a look.
I don't have any questions about that. Exhibit 21, the people admitted that from Jennifer's device, it appeared she Googled or searched for research clinical depression treatment options. Is that correct?
Yes, ma'am.
And you don't know if she was researching clinical depression treatment options for herself, or for her son, or for, you don't know who that was regarding, correct?
Yes, ma'am. Correct.
It doesn't say in the search who she was looking for, correct?
Correct.
So, and in addition to that, that's the only search that you provided for this court, although I imagine Jennifer searched for many, many things on her phone at various points in time, correct?
Yes, ma'am. Correct.
And if you had seen something in one of Jennifer's searches, like homicidal child, or what do I do if I believe my son is going to shoot students at a school, you would have brought those searches into this court and shown them to us, correct?
Correct.
There were, in fact, no searches along that line. The closest, most relevant search you found was this research clinical depression treatment options.
Correct.
On Exhibit 22, you admitted, the prosecution admitted through you, a couple of pages of text messages between Ethan and his mother. Do you recall seeing those?
If I can see them, just to make sure we're talking about.
Sure, no problem. Okay, so those texts were admitted, and they're approximately 4 or 5 pages long. Is that about right?
Three pages.
3 pages. Okay. And when you look at the total, we print out all of the texts between Ethan and Jennifer, and this is going back to June of 2020 up through 11/30 of 21. There's far more texts between Jennifer and her son than just those 3 pages.
That was a lot of
correct?
text messages.
May I approach to grab those? Yes. Thank you. Now, on these text messages, Ethan is saying things along the lines of, there's someone in the house, I think, someone walked in the bathroom, I thought it was you, when I came out no one was home, there's no one in the house though, dude, my door just slammed. Ethan is sending his mother a series of messages claiming there's someone in the house or there's something going on, correct?
Correct.
And in all fairness to Ethan, you don't know if there's somebody in his house, correct?
I'm sorry, what's the question?
You don't know if there really was somebody in his house, correct?
I don't. Correct.
And you don't know also if there are phone calls between Jen and James or between Jen and Ethan at the time that these texts are being sent, correct?
I believe we looked at that, and I don't believe there were any phone calls between them.
The way you would look at the phone calls, though, would be looking from Jennifer's cell phone to Ethan's phone, correct?
And reverse, yes.
In reverse, but if Jennifer was to use the phone at her office, like on her desk, that would not appear. In the search in terms of a call between her and Ethan, correct?
Sorry about that, guys.
Did you look to see if on Ethan's phone there were calls?
Yes.
And you didn't find any calls?
I don't recall any of them.
The time these messages are sent, the truth is we don't know if there was someone in the house or what was going on, correct?
Correct.
It's impossible for us to take 3 pages of text messages and understand the complete context.
Object to the form of the question, Your Honor. That's a decision for this court.
That's the state. Go ahead and rephrase this.
It's, whenever we're looking at text messages, the text messages don't say the context within which they were texted, correct?
I'm sorry, I don't understand the question, I apologize.
I think it's a bad question, and that's my fault.
Okay.
I'm gonna move on.
Okay.
Exhibit 23 continues to be messages between Ethan and his mother. Do you recall admitting those, or providing those to the prosecution and them being admitted as Exhibit 23?
I believe I do, if I can just look at it real quick. Thank you. Okay, I remember this now.
Okay.
Yes, ma'am.
And these text messages mostly start off with Ethan texting his mother that he believes the house is haunted, that weird things are happening and he's scared the house is haunted. He claims he got some videos and a picture of a demon, correct?
Correct.
Now, in looking in his phone, you found no videos that would match what Ethan's talking about, correct?
Correct.
You found no photographs of demons, correct?
Correct.
And Ethan says here, I am not joking, it fucked up the kitchen. In all honesty, you have no way of knowing whether Ethan's joking overall or not, correct?
Correct.
Okay, we're gonna stop right here because not only because we're out of time, but this is very offensive to me. So we now know what happened. The detective read the text, and we'll probably see what needs to happen here. I'll be back in a moment. Before we leave, let's give you a quick recap here. The parents of Ethan Crumbley are charged with 4 counts of involuntary manslaughter just days after his son allegedly was shooting several people at Oxford High School on November 30th. 4 students died in the shooting and 7 others were severely hurt. Ethan is charged with murder and is still being held in jail. If the judge agrees with Ethan's attorney, he will be moved to a juvenile correction center. That's only if the judge agrees. So we'll have to wait on that. Meanwhile, tomorrow on the show, a special treat. Sports fights. It's all going to depend on the weather. You guys I know you probably like me going out there, all these sports games, but it's going to depend on the weather. Too cold, I'll have to bundle up. So look for that. But the judge ruled the parents were at flight risks. So that's the very latest from from Tuesday's hearing. But I'll try to give you more about this on Give Me a Break Saturday in a couple days. So look for that in a couple days. But that's all for this edition of Give Me a Break Thursday. See you again tomorrow for Give Me a Break Friday, depending on the weather. If not, we'll probably do this in the studio. Have a nice day, everyone. For all of us here at YouTube, have a nice day.